Bingham's not here yet. He comes, he'll just play catch up. Move on, but since we have enough for a start, because we have a quorum, we'll go from there. So this time, call the special meeting on case number 2476. Colebrook Associates Venture LLC application in front of this board to order. Since this is a special meeting, we only have this case tonight, and we'll proceed from there. Members of the board who are present this evening, Mr. Hanson, Mr. Kyle, myself, and we are expecting Mr. Bingham sometime this evening. Mr. Lewis will not be here, he's on vacation. We have also this evening our solicitor, Jason Hess, zoning officer, Ram. We have on Zoom young lady by the name of Judy, who is taking the board minutes for us. We also have a court reporter present who is taking official minutes. As I stated, we only have this case this evening. This board will hear this case, continue to hear this case in an informal manner without strict compliance with rules and procedures used in court trial. We ask that the applicant and any individuals interested in this case step in front of our table and explain the circumstance involved in their application. The applicant may present their case themselves through their attorney or other representatives. Our board members and I, as well as the solicitor, may ask the applicant questions from time to time during the applicant's presentation or at its conclusion. All persons having an interest in this application will be given the opportunity to ask questions of the applicant, offer evidence of their own, inform the board of their position on the matter. In the interest of a prompt and orderly disposition of this case, we asked interested people to refrain from speaking until the applicant's presentation has been completed and the board has had the opportunity to question the applicant. At the beginning of the case, people who are interested in this case should decide whether they desire to be parties to it. Like being given the status of a party, that person will be entitled to receive notice of the decision in this case. Excuse me. And will be entitled to receive notice of the decision, will be entitled to participate in any subsequent appeal or rehearing. Individuals who are not given party status may nevertheless ask questions, present evidence, but will not receive notice of the decision and will not automatically be entitled to participate in any appeal or subsequent rehearing. If you desire to be a party, we will ask you to sign an entry appearance form at the appropriate time. And although each party will receive a written copy of the decision, the mechanics of typing the decision and signing the decision will take approximately 4 weeks. We ask that each person who asks the question or makes a statement first state his or her name and address for the court reporter. Also, please speak in so the mics pick you up so that Jimmy can get the board minutes. Now, in the interest of time, I will administer the oath of affirmation to the applicant and to everyone and anyone who anticipates making any statement with respect to this hearing this evening. So at this time, will you all rise, please? Under penalties of perjury, you swear or affirm that the testimony you will give is the truth, the whole truth, and nothing but the truth. If so, please say I do. Stay standing and please rise. Salute the flag. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. Beth, this continued hearing has been properly posted in accordance with Sunshine Law and the MPC? Gentlemen, you should have received minutes from the June 20th, received board minutes from the June 20th special meeting pertaining to case 2476. If there are no additions, deletions, or corrections, I listen to a motion pertaining to the board minutes. So moved. Motion by Mr. Hanson. Do I have a second? Second. Second by Mr. Cobb. Any discussion, gentlemen, on the June 20th board meeting minutes? Seeing none. Mr. Hanson? In favor. Mr. Cobb? In favor. And I'll also vote in favor. The board minutes of June 20th, 2024 have been approved. Okay. Before we move forward, Jason, anything you need to bring forward? Not at this time. Okay. Beth, would you like to call up the case, please?
Case number 2476, Colbert Associates Venture LLC filed a substantive validity challenge pursuant to 916.1A1 of the PA Municipalities Planning Code relating to its property at 10B Way, parcel number 290-51654-00000, located in the medium density residential zone. Claiming the zoning ordinance unlawfully excludes high density multifamily dwelling.
Okay. Mr. Name.
Good evening.
I'm not sure.
No,
You were done with.
I was done with his prior expert.
Okay, so we're to you.
Yes, we're ready to call our next witness.
Say something else, please. Just even say hi to me or whatever.
Good evening, Mr. Herr.
Judy, can you hear him? And Judy, you're me.
Yes, I can.
Okay, thank you. Thanks, Mr. Mayor.
The applicant calls Michael Samuels. Mr. Samuels, you've already been sworn. Can you please state your name and your place of employment and your title where you're employed?
Yes, Michael Samuels. I'm the president of Clarion Samuels Associates, located at 999 Old Eagle School Road, Wayne, Pennsylvania.
I'm going to show you a document marked A40 for identification. Can you please identify that?
Yes, that is a statement of my qualifications.
Does A40 accurately reflect your education, experience, and qualifications?
In a highly summarized fashion, yes.
And you said you're the president of Clarion Samuels, correct?
That's correct.
What services does Clarion Samuels provide?
We're a real estate consulting and valuation appraisal company. But we provide a wide range of services in the real estate appraisal and consulting realm.
Where is Clarion Samuels based?
Well, Clarion Samuels is based in Wayne, Pennsylvania, but we're part of an affiliate network of offices in Denver, Cincinnati, and Chapel Hill, North Carolina.
And what is included in the services of the affiliate network?
While we provide, as I said, primarily real estate consulting, real estate market research, and valuation services. The other offices are populated with lawyers and planners. And they provide services such as the rewriting of zoning codes, the writing of comprehensive plans. They work in a municipal realm, while we tend to work in the private sector. And then occasionally we work together. Our Denver office was hired, that's about 12 years ago, to rewrite the Philadelphia zoning code. And I participated in that. And I provided various services in the testing of the economic testing of density bonuses that the city wanted to provide incentives for developers to design projects in certain ways and provide certain features within projects, access to subways, walkways that connect to other walkways, green space, thinking of setbacks, courtyards, things of that nature. They were trying to incentivize building garage parking under buildings rather than next to buildings or surface parking, or and that would be underground. So there are 3 types of parking: fully underground, under buildings but above ground, and then above ground in adjacent parking garages. And our job was to help determine what types of incentives in terms of additional development potential or design changes that would incentivize developers to provide the types of design in their new projects that the city was hoping to achieve.
Is it fair to say that you have experience in appraising, analyzing, and advising with respect to both urban and suburban development?
Yes. We work primarily in southeastern and south central Pennsylvania, but we do a substantial amount of work up in the Spanish area. We worked in almost every county in New Jersey. We worked for the New Jersey Farm Bureau that was under attack by downzoning, and we had to determine what the impact of downzoning was on agricultural land throughout the state of New Jersey. We've in conjunction with our Denver office, we work for 10,000 Friends in Pennsylvania and the Pennsylvania Environmental Council. And we did a study where we tried to measure the cost of suburban sprawl in Pennsylvania. And so we had to look at metropolitan areas, if you will, across the state. We looked at Philadelphia and Pittsburgh as large, York and the Lehigh Valley as medium, and Williamsport and Meadville as small areas that were experiencing sprawl in their own way. So we did an extensive study from that, presented the results of that to the community at the Federal Reserve Bank of Pittsburgh.
Are you a certified appraiser in Pennsylvania?
I am. I'm a certified appraiser in Pennsylvania, New Jersey, Delaware, Georgia, and Florida. They have had temporary licenses in a dozen other states. And I'm currently temporarily licensed in the state of Tennessee, where I've been working on determining the value of declarant rights in a 1,300 lot amenity-based community.
Can you walk the members of the board through your educational background, please?
Yes, I have an undergraduate degree in finance and real estate from the University of Illinois. The education at the University of Illinois is much better than our sports teams, unfortunately. And I have a Master of Science in Real Estate Appraisal and Investment Analysis from the University of Wisconsin.
Do you hold any professional designations?
I hold several. I have 2 designations conferred by the Appraisal Institute. The Appraisal Institute is the foremost advocate for appraisal, advancement, and education in the United States. I had their highest designation, the MEI designation. It at one time stood for member of the Appraisal Institute. I also have an AI GRS designation, which is their special certification for people qualified in a review of others' appraisal reports and reports in the real estate advisory world. I have a CRE designation. CRE stands for Counselor of Real Estate. It's a national organization. Membership is by invitation only in recognition of excellence in real estate consulting. And then lastly, I have the FRICS, which is a fellow of the Royal Institute of Chartered Surveyors. It is the largest real estate appraisal organization in the world, based out of London.
How many years of experience do you have?
I've been in the real estate business for 44 years in various capacities. I've done, for several years, I worked for the 10th largest accounting firm in the country, doing primarily market studies and consulting for developers. I worked for years in the real estate investment department of a life insurance company. And I worked for 3 years in property acquisition and development approvals, so development activities for a regional developer based out of Philadelphia.
Have you worked on projects in Lancaster County?
I have approximately a dozen. I've been working on the PennDOT condemnation of right-of-way at Goods Plaza for about 10 years now. That condemnation took place in 1999. So we had to put ourselves back in the world of East Hempfield Township in 1999, which is quite a bit different than it is today. But I've done a variety of subdivision appraisal work. I've done consulting for Federal Realty Trust, doing the shopping center right off the Route 30 bypass in a challenge to a deed restriction that was placed on the property by a restaurant that had been in place since before the bypass was constructed. And so I've done a variety of things in Lancaster County.
Have you served in any municipal roles?
Yes, I was on the planning commission of the most populous township in Cheshire. I served on the planning commission of the most populous township in Cheshire County, Tredyffrin Township, at a population of about 30,000. I was on that for 9 years. I was vice chair for 8 of those 9 years. And then in our work, we do a lot of work in eminent domain. And so we not only work for private sector clients, but we work for a variety of school districts and a variety of municipalities.
Have you testified as an expert and been accepted as an expert before municipal bodies in Pennsylvania?
I have, through a lot of municipalities, ranging from up in the Scranton-Wilkes-Barre area, all the way down through the Lehigh Valley and Philadelphia, all the surrounding communities, Lancaster County, Dauphin County, and municipalities in southern New Jersey. I've also testified in common pleas courts and before courts of view in Philadelphia, Chester, Montgomery, Bucks, Delaware counties, Lehigh Valley, Lancaster County, and York County.
And in that testimony, had you been accepted as an expert as well?
Yes.
And have you been accepted as an expert in federal court?
I have Eastern District of Pennsylvania and Southern District of Florida.
Have you prepared fiscal impact studies?
I have probably about 24 times, all on, land for development, either for continuing care, retirement communities, or market rate apartment communities.
Based on Mr. Samuel's resume and testimony, I'm going to offer him as an expert in real estate market analysis, real estate appraisal, and fiscal impact studies. I have one more question. Are you also a licensed real estate broker
I am, yes.
and also in real estate brokerage?
Look, so.
Well, are there any qualifications?
Yeah, I do have a couple questions. Mr. Samuels, when you've been qualified as an expert to testify in court, has that been in your capacity as an appraiser?
Either as an appraiser or in market analysis, highest and best use analysis.
Okay. Have you ever been qualified as an expert with regard to fiscal impact studies?
I've only testified regarding fiscal impact before municipal bodies.
Okay, so you've not been qualified in court for fiscal impact studies as an expert?
I have not, no.
Okay. All right, I have no objection to Mr. Samuel's qualifications as a real estate appraiser or an expert as a real expert in real estate appraisal or real estate market analysis. I do object to his qualification, though, as an expert on fiscal impact studies. His testimony was limited to he has prepared about a dozen studies. He's not been qualified in court as an expert.
May I respond?
We will accept you on the limited basis that so far.
Okay, thank you.
I've been like, please, an opportunity to address that objection.
Oh, okay. Take that back then. I didn't appreciate it. I'm sorry.
So, Mr. Samuels, the solicitor for the township has objected to your qualifications to testify as an expert in fiscal impact analysis. Can you provide any additional background that would address that objection?
Well, first of all, issues of dealing with fiscal impact rarely get to court. And so, I have done it about a dozen times. I said I've done it 24 times. And they've been for apartment complexes throughout the Delaware Valley. They've never been questioned. They've always been accepted by the municipal boards for whom I've presented before.
On that basis, I would reoffer Mr. Samuels as an expert in fiscal impact analysis.
And I'm going to reassert my objection to that. We haven't heard of any specialized training or knowledge in that area.
Okay. Okay, excuse me. In consulting with counsel, we will accept Mr. Samuels as an expert witness in the two areas. that the township solicitor has no problems with. And based on his qualifications, both in stated in applicant's exhibit A40 and the explanation that was given on the third provision, we will not accept him as an expert witness, but we will accept the testimony with the understanding that we will take it basically on face value, but it will be limited to that.
And I'd also offered him as an, in real estate brokerage, which wasn't objected to.
I did not hear that offer. Do we have, okay.
He did testify that he's a
That's
licensed.
fine. I have no objection to that. It's just limited to the fiscal.
Mr. Samuels, are you familiar with the substantive validity application that was filed with the zoning hearing
Mr.
board?
Herb, before we begin with this witness and the substance of this testimony, I would like to ask for an offer of proof. And the reason is this: shortly before 5 o'clock tonight, I received 3 expert reports from council. I have significant objections to 2 of the 3 of them. So I don't want to go down this road of getting into testimony until we clarify exactly what he's going to be testifying to, because I would like a chance to assert my objections early on.
Okay.
Okay.
That's reasonable. See, there.
Well, I think council needs to provide an offer as to what his testimony is going to be from his
I
expert.
understand. You tell the board 2 of the 3.
Sure. There are 2 of the 3 reports. The first one is a report in which the witness is going to give an opinion to address the marketplace at the time that the applicant purchased the property, and the potential reasons why they did not attempt to construct the previously approved land development plans prior to the change in zoning in 1994. This is an interesting question, but it's not relevant. The witness, the very first witness you heard from on the first night, answered Mr. Hansen's question on that.
Right.
It doesn't go to the question of whether or not this is a de facto or de jure exclusion of high density residential housing. You know, what they did and why they did it, again, interesting, but has no bearing on the decision before you tonight. Their client is the best person qualified to give that opinion, not this expert witness. And frankly, his opinion doesn't rise to that standard that we need from experts. It's highly speculative. And actually, his opinion is only, it's reasonably likely that construction was not pursued for a specific period of time. Also within that report, it is full of hearsay. There are lots of quotes from logs, internet reports. Again, interesting from a historical perspective, but not at all relevant to the inquiry before you. So that's one.
Can we take them one at a time, please?
And yeah, you can go back to that, but can we just hear what the 2?
Okay. Second objection, and perhaps the qualifications issue may resolve this, but the witness has prepared 2 fiscal impact studies. Now, mind you, you have not qualified him as an expert in fiscal impact studies. The studies evaluate the revenue and expense generation to the township and the school district, and there's reference to the sewer authority if these high density residential units are allowed to be built within the township. Again, this has nothing to do with the test for a substantive validity challenge. It's interesting, it's speculative, and as you all know, the formal rules of evidence don't apply here, but you are required to exclude irrelevant and immaterial information. And our position is this has no bearing, you know, evaluating the township's budget, evaluating the school district's budget, figuring out how many kids may or may not be in there and what the impact is if the ordinance allowed for this level of high density residential development. Again, it has no bearing on whether or not this ordinance as written is exclusionary. So those are our 2 objections. I would ask that the board exclude any testimony that gets into those two reports.
Now, back into the issue between councils here on, I think you should, Nagel has some questions or objections to your comments. So.
Yeah, well, first I'll respond to the why wasn't it built issue and why that's relevant. Number one, one or more members of the zoning hearing board asked about that very topic. And there's two aspects to that topic. There's the element of, from the owner's perspective, why it wasn't done. But there's a further explanation to that from a market analysis standpoint that relates to the timing of the township's revision of its zoning ordinance to limit the density for multifamily housing in the township. And it speaks to that issue. To some degree, there's a background element of it, but to some degree, there's an element that does go to the substantive validity of the township's ordinance and the action that the township took to reduce the multifamily density. So I would submit that it is relevant. I would submit that you allow the testimony, and then the zoning hearing board will be free to give it the weight that it feels that it deserves.
Can I just ask a quick question, Mr. Hanson? So can you tell us, the board, why it's appropriate for this witness to give testimony on why the applicant didn't construct the development at the time?
Yeah, I understand the characterization of the report that I shared with the township solicitor by the solicitor, but that's not the only thing that testimony will cover. It also will cover the market conditions relative to multifamily development, both before, during, and after the township's passage of the zoning ordinance restricting the density of the multifamily development. So it covers a number of topics that certainly are relevant to this application and relevant to the substantive validity issues in this case.
I think that the board would like to hear you respond to the objection of the second report, and then we'll address both of them.
Sure. One of the standards in these cases is that you have to establish that the development is appropriate for the property and the surrounding township. So the testimony on the fiscal impact isn't to get in and analyze anything having to do with the school district budget or the township budget, but rather to explain and offer into the record information about the impact of the relief that the applicant will ultimately be requesting in this case. And that's very important to the board's consideration of this case and is relevant to the application that's been filed for sure.
If I may, our position is that is absolutely not the test in a substantive validity challenge. You know, the impact of changing the ordinance. The question is whether this is exclusionary. Your scope of review is very limited here, and that is the sole question. These fiscal reports are quite lengthy. They do get into budgetary information and analysis of both the township and the school district. One suggestion I have is perhaps we take a break and allow these reports to go to your solicitor only for his review. I realize you're trying to make a decision without the benefit of this information before you. But again, I stand by my position. This has nothing to do with the case before you. It is immaterial and it should be excluded.
May I respond to that?
Were you done?
I am, thanks.
Yes, Mr. Nagle.
While, first of all, the testimony, while the reports contain a lot of information, the testimony about the information covered in the reports is not lengthy. Second of all, while the test for the substantive validity challenge itself doesn't include any proofs relating to fiscal impact, the relief that has to be considered does include a consideration that would include a number of issues, including the fiscal impact of the development I would submit. And so with the standard being relaxed rules of evidence in a zoning proceeding, it is relevant. You can't know that it's not relevant until you hear it. So I would suggest that the board allow the testimony and then it can decide to give it the weight that it deserves.
If I may, a fair amount of this fiscal impact analysis relates to the school district. School district is not a party to this case. Neither is the sewer authority. And there are comments made within this report as to the benefit of the sewer authority if multifamily high density residential uses were allowed. Again, we don't believe it's relevant.
I think that in my discussion with the board, I think the board's going to allow the reports to come in. There's going to, as to the first report, the testimony should not include any sort of anything that would be speculative on the expert's part about why the applicant did or did not do anything in the past. It should focus solely on, you know, issues of marketability and things like that that would be within the realm of the experts, you know, knowledge base. And rather than taking the time for me to look through the reports and everything, the second report, you know, I think the board is willing to allow some limited testimony, but if it gets into things that are clearly not relevant to the board's determination, you know, it might be a little bit of a short leash, and they'll give the evidence and testimony the weight it deserves.
If I may just address, the first report is entirely speculative. There is language in here talking about potential reasons, you know, and again, it is full of unsubstantiated internet reports. It's hearsay, and there's no exception that's going to apply here. So again, I renew my objection. I understand if the board wants to proceed and allow it to be, and I would ask for a standing objection as to any testimony on both reports. I'm trying to help shorten this up here because I think we're going to go down a very long road tonight with a lot of information that just has no bearing on your ultimate determination.
May I respond to that?
Yeah, you can. Okay, Mr. Eagle, you may respond to Ms. Pfeiffer's last comment.
The testimony itself is the evidence, not the reports. So that will bear out in the testimony of the witness, number one. And secondly, I don't agree with the characterization of information relied on as hearsay. Expert witnesses are allowed to rely on any outside information that those types of experts rely on in the normal course of doing their work. And certainly an appraiser relies on all of the different things that the township solicitor referred to as referenced in the report in conducting appraisal reports and other work that they do, including market analysis. They rely on all kinds of published data, articles, and other types of information ordinarily in the course of doing their work. And they're allowed to rely on that and testify about it under the strict rules of evidence in Pennsylvania, let alone under the relaxed rules of evidence in a zoning proceeding.
Comments?
I think I've stated my position.
Okay. Again, after consulting with the solicitor, what we're going to do is allow Mr. Naylor to proceed with these two documents that have been referenced. If at any time that, which you would already know this, but you have objections to whatever Mr. Nagle brings up or Mr. Samuel states in response to questions asked, please raise the objections. We'll take each one. I know this could drag this hearing out, but I think, and the solicitor agreed that no matter what our decision is, it potentially could be appealed. And I think the record should show that we give all the deference possible so that the court doesn't remand it back to us. But especially if this does continue for a number of hours more, I don't want to sit through this a second time, ladies and gentlemen. So let's proceed. And also, if I rule in Ms. Pfeiffer's side, please do not try to bring the same issue back up, only worded different. We've had that in the past here where an attorney will ask a question, it's challenged. We agree with the challenge, and then the attorney turns right around and asks the same question, but words it differently. And we go through a second challenge. So just telling everybody some of the rules, because we don't follow strict rules of procedure. Just wanted to lay that out so everybody knows where this board is coming from too. So with that, Ms. Piper, you had started with your objections. Anything else you want to say before we?
No, that's fine.
Mr. Nagle, please proceed.
I would just add that the solicitors made a standing objection,
Right.
and would be free to raise that on any appeal with the court. So there's really no need to waste a lot of time continuing to argue about it.
But the issue is, we have not seen the report. You raised either a statement or you asked Mr. Samuels and he responds. I don't know at this time, even though there's this standing objection, I don't know if that's objectionable or not, unless Ms. Piper brings it to our attention. So, yeah, I don't want to sit here any longer than anybody else, but you know, there are certain things that we have to do to stay in compliance with, you know, the courts, and so we'll go there. So we ask that you start, and you know, Ms. Piper understands her part of this.
Very well. Mr. Samuels, are you familiar with the substantive validity challenge and application that was filed with the zoning hearing board in this matter?
Yes, I am.
Have you reviewed the transcripts of the hearings in this case to date, dated March 21st, April 19th, and June 20 of 2024?
Yes, I have.
Have you reviewed all of the exhibits that have been introduced and admitted into the record of this hearing to date?
I believe so, yes.
Have you visited the property that is the subject of this application?
Yes.
Do you know when my clients purchased the subject property?
Yes, February 27th, 1989.
Are you familiar with the 1971 land development plan that was marked as A5 earlier in the hearing?
Yes.
Does the existing development at the subject property match the 1971 plan?
The existing development reflects one of two phases, where the first 343, I believe it was, 342 units were constructed, and the rest of the ground, 27 acres, remains vacant.
Is the density that was developed or the development at Colebrook from that partial development from that plan is the development that resulted from the partial development of the 1971 plan less than half of the units that were approved on the 1971 plan?
Yes, that's correct. There were 713 units that were approved. There are 371 units yet to be built.
And is it your understanding that the maximum density for multifamily housing of the 5 dwelling units per acre that exists today was introduced in the township's 1994 zoning ordinance?
That's my understanding, correct?
Are you aware that the owner did not attempt to construct the balance of the 1971 plan after purchasing the property and before the 1994 zoning change?
I'm aware they did not construct anything. I do not know if they made any efforts to construct. I don't know if they submitted any plans. I'm not aware that they did. I'm not aware that they spoke with anyone in the municipality about, continuing any efforts to develop that 27 acres.
You are familiar, though, that the board had asked Mr. Polinsky why they didn't develop the property?
Yes, I remember that in the transcript.
And did you conduct an analysis to determine why a property owner might not have constructed or would not have constructed the balance of that plan?
Yes, I did.
I'm going to show you an exhibit marked A41 for identification. Please identify that document.
Yes, that was a report that I wrote and produced in this case.
And what documents did you review in the course of preparing this report?
Well, obviously, I reviewed the 1971 site plan with the approvals for the 713 units. What I reviewed and inspected what had been constructed. And then it was Mr. Hanson in the transcript who brought up a very good question. And that was, the ordinance was changed in 94. Now, we say 94, but in fact it was January 13th of 94. So it's really, effectively the end of 1993. But the question was, why they had that opportunity for those years? Why didn't they? And Mr. Polinsky, really couldn't answer that question. I seem to recall he said he was too young. He didn't know. And so this report tries to answer the question of what were the market conditions at the time. Were the market conditions supportive of new apartment development, or were they not supportive of new market, supportive of new development of apartments? And I lived through that. It was a very painful time economically for the country. and for the real estate business in particular. We had a boom in apartment construction through the early 80s.
I'm going to object to the extent this testimony is going beyond the limits of the question that was posed. I think he asked, the question was what documents you reviewed in preparation of the report. I think he's answered that question, and now we're getting into more the substance of his testimony. So
Perhaps a new question.
Yeah, no problem. What were the market conditions at that time?
The market conditions were that, and again, as a real estate, a licensed real estate appraiser, certified in multiple states. So we have a responsibility to do our work within the guidelines of very strict professional standards, the uniform standards of professional appraisal practice. And those standards address retrospective opinions, because appraisers are required to sometimes appraise properties and consult on properties and do market analysis on permanent times. Sometimes we have to do prospective work. What is it going to be like in 6 months, a year, 2 years? And many times we're asked to do work retrospectively. There are certain requirements that we have in terms of people that we have to talk to, documents that we have to review, to put ourselves back into the time period in which we're discussing as true professionals. And as I said, so I reviewed a lot of documents published by HUD, by the Bureau of Labor Statistics, by the Federal Reserve, in business publications like Forbes and CoStar and other sources that we rely on all the time for our market research. So I'm going to start back in the early 80s only because it's important to understand for the context of where we were from 1989 to the end of 1993, what happened prior to that, and what the reactions of the marketplace were to those circumstances. Early in the early 80s, 81 and 82, there were tax acts that changed the nature of the real estate development business and the development of apartments. It accelerated depreciation. It changed the way that investors were allowed to reflect tax losses. The real estate syndication business took off. Hundreds of thousands, not millions, of apartment complexes were constructed at that time because there was a demand by investors to own them, but there wasn't necessarily demand by households to occupy this. The 1986 rolled along, and the Tax Reform Act of 1986 changed all of those rules in terms of active and passive losses. It took depreciation from 15-year accelerated to 31 years and longer, changed the economics of the apartment investment and development business. In the middle of the 1980s, there was also a liquidity crisis in the savings and loan industry. Their cost of funds were far in excess of what they could invest those funds in. So the S&L industry was deregulated. It took about 4 years for the S&L industry to collapse. It was the biggest series of bank failures in the history of our country. And in 1989, the Resolution Trust Corporation was created to try to take over failed institutions and resolve them, and to do something with all the assets that these banks had. And they had a lot of assets. So Congress passes a law in '89 to try to restrict what S&Ls can do and the banking industry can do. It made a dramatic impact on the ability of developers to construct primarily multifamily housing, but also office buildings, shopping centers. It also prohibited direct equity investment by these financial institutions. So that's what led up to the time we were going into a severe real estate economic recession. August of 1990, we have the first Gulf War. We have a national economic recession from July 1990 to March 1991. There's in great detail what's happened. Unemployment rate increased during that time. Gross domestic product contracted by 1.4% in 91. Industrial production declined by 4.5%. Apartment vacancy rates increased to 10%. The ability to pass along rental rate increases declining. In 1988, rental rate increases were 5%. By 1994, they were 1% nationally.
Mr. Hanson has.
Mr. Noggle, so far, Mr. Samuels has said quite interesting as a history lesson, but again, I'm not sure how that pertains to this particular.
Well, it's a fair question, and going further to the solicitor's objection, the township opened the door to this testimony. The township solicitor, when my client testified, asked my client, despite the purchase of the property in 1989, no efforts were taken by the owner to come into the township with a plan until 32 years later. Isn't that correct? And so no efforts were taken by the owner between 1989, when the property was purchased, and 1994, when the township changed the zoning ordinance. Isn't that correct? And so by asking my client those questions, the township opened the door to a explanation, a market-based explanation as to why my client didn't build the units that were available in the 1971 plan. And I think the testimony is on that issue is nearly complete. I know there's a lot of background on the market conditions on that question I asked, but it's not much more.
Okay, thank you.
Thank you. Continue.
Sure, I'll try to keep it short. So we were effectively in a real estate meltdown in the United States during that time. So the number of projects that were constructed from 1985 to 1989 in Lancaster County, there were 1,380 units built. 1990 to 1994, it dropped to 909. Then 1995 to 1999, it went down to 260. If you look at it on an annual basis, there was one project of substantial size, 513 units, completed in 1990. And that was it. In 1991, there were two projects totaling 210 units. In 1992, there were 0 constructed. 1993, one project of 60 units. 1994, one project of 66. Developers do not build into a declining market where they know they're going to have a difficult time absorbing units because of what was happening with unemployment and with the lack of job growth and the lack of income. Vacancy rates are increasing, and they're in a lending environment where no one wants to lend money for new construction projects. And the banking system, after the 89 financial institutions reform, recovery, and enforcement idea, also tie the hands of a lot of lending institutions that local developers rely on. One of the things that happened, they did well. They made sure that no lending institution could have more than X% of their assets exposed to any one client, one builder, one developer. And at that time, there were a lot of builder developers who relied on a single bank for all their financing. And they were now scrambling because the banks had to divest themselves of those loans. And there were not loans available from any other sources.
I'm going to object to any further testimony along these lines. Again, there's no correlation here between this actual applicant and then that is what happened to them or those were the reasons. Whether I opened the door, Mr. Hansen opened the door to this line of questioning, again, it's interesting by way of background. It doesn't go to your inquiry, but furthermore, this is historical information. Perhaps it's speculative at best, and there's no tie to this applicant. Their client is the best witness for this testimony, not an expert.
Can I ask a question, you, Mr. Nagel? Is there, what is the relevance of, well, I mean, if it wasn't developed in between 1989 and 1994, what is really relevant? Why is that part of what the board needs to decide?
Well,
why is it relevant?
at a minimum, with the suggestion of the township solicitor that my client should have built it when they had the opportunity. And Mr. Samuel's testimony is, given the market conditions, they couldn't have. That enough alone is to make it is alone enough to make it relevant in this proceeding. There's other testimony that will come later that will tie this in further in the current circumstances. But that alone is enough, and we're finished with the testimony basically at this point as it is.
Okay, I mean, despite whether the township's attorney brought that up or not, I mean, it's still, even if she asks a question, it doesn't make it relevant to the board's determination. So
the board can make that determination. I'm just trying to offer the testimony that is necessary in the application and that's come up in the course of the hearings. So the last question is, do you have a professional opinion drawn to a reasonable degree of professional certainty, not speculation, but an opinion drawn to a reasonable degree of professional certainty as to why Colebrook or a similarly situated owner or developer would not have completed the balance of the 1971 plan in that time period?
Yes, economic conditions were such that it is unlikely that anyone would have started construction of a new apartment complex at that time.
Just on your objection, I'm going to sustain on the thing that, but as Mr. Nagel then went on, and that line of testimony is now complete. We should proceed further, but understand it. I agree that the history is one thing, but there are other issues out there. Plus, the legislature during this time gives them benefits to developers where they could proceed with plans and have the luxury of not having their plans affected should the town, in this case, the township, change its ordinances. So
just so we're clear on the record, when you say you're sustaining my objection, I want to make sure which objection, as to the testimony or the
last one that you just had said that it was hearsay, and going back and where Mr. Nagel had said that you had raised the issue and brought it forward. Understand that, we understand the history, but you know, I would agree that that is in the past and we're looking at it moving forward. So yeah, I'm going to, and plus Mr. Nagel then also, before I was able to make the comment, said that testimony is with at least with this witness is complete, and he's going to move forward.
Okay, so as I understand it, just because I want to try and keep
Sure.
it moving here. So you are sustaining the objection that this is not relevant for purposes of this case. And if that is your ruling, then I won't have any cross-examination for the witness on this particular topic. I just want to be clear that it's correct. Okay, thank you.
Mr. Noble, if you ask a question, Mr. Shannon was clear about the owner of the property didn't do any construction because of the economic conditions between 1989 and 1994. Is that correct? Is that what we testified to? Okay, so what about after 1994?
After 1994, the zoning changed.
I understand. So 20 years later, decided they want to go.
I can't explain why or when or the actions.
Mr. Samuels.
Yes.
Get a little closer.
Yes, all I can say is that, you know, economics change, you know, dramatically over a period of time. When we look at a history of apartment development in Lancaster County, there was, you know, ample reason why it would not have been constructed prior to 2000. 1995 and 1999, all 260 apartments were built, and they were built in 2 small apartment complexes. And then it wasn't until 2000 that the market conditions were right for new construction. And then, you know, like all real estate markets, everything is cyclical. You know, if they had built it from 2000 to, you know, 2006 or so, the marketplace would have been wrong then, and we're in another real estate recession. And it wasn't until 2014 or 15 that the real estate market really returned. So why didn't they develop this since 2015? I don't know. Market conditions were excellent from then through the pandemic, and then accelerated through the pandemic in 2020 and 2021.
I am going to make a further offer of proof on the fiscal impact testimony that Mr. Samuels is going to give. One of the issues that's been raised in this case is that the township zoning ordinance violates municipalities planning code section 604. That section of the Pennsylvania municipalities planning code requires a zoning ordinance to provide for the use of land within the municipality for residential housing of various dwelling types encompassing all basic forms of housing, including single-family and two-family dwellings, and a reasonable range of multifamily dwellings in various arrangements. On that basis, in the fiscal impact testimony, you will hear testimony that based on some of those fiscal impact characteristics and the implications that flow from them, that leads to a further violation of section 604 of the MPC. So this testimony goes not to the issue of the question that Mr. Hansen had asked at the last hearing about what are the tax implications of this development, though that issue was raised. It also goes to the provision of appropriate multifamily housing for all housing types to accommodate people who need housing in the township. The applicant has also raised a Fair Housing Act legal problem with the township zoning ordinance, and it goes to that issue as well. So this testimony is relevant on those subjects in addition to the subjects that I articulated earlier.
Let me start in reverse order. The report doesn't get into the Fair Housing Act at all. It is limited to a fiscal impact study. You have not qualified this witness as an expert. The MPC section that he refers to specifically states no zoning ordinance shall be deemed invalid for the failure to provide for any other specific dwelling type. It asks for a reasonable range of multifamily dwellings. The testimony this witness is going to give is limited to new multifamily dwellings. Township, when we get to our case, will put on its case to demonstrate that there's other ways that you get to multifamily dwelling. It can be repurposing of current existing buildings, that there are developments going into the township where there is multifamily dwellings being put in. I mean, this is not a case where there are absolutely no developments. There are developers in the township now actively working through plans or have in recent history. So, you know, this is a stretch to say that this fiscal impact study focusing on the budget of the township and the budget of the school district and the number of students that may go in or out of the school. If this developer can develop the property in the way in which they desire, again, it doesn't go to the question before you as to whether or not the ordinance as written is exclusionary.
I'd like to respond to that. On the first point, the characterization of, I disagree with the characterization of section 604, where the solicitor quoted the language that says, no zoning ordinance shall be deemed invalid for the failure to provide for any other specific dwelling type. What 604 says is that a municipality has to provide for various dwelling types encompassing all basic forms of housing, including single family and two family dwellings, and a reasonable range of multifamily dwellings in various arrangements. It then goes on to say, provided, however, that no zoning ordinance shall be deemed invalid for the failure to provide any other specific dwelling type. So it identifies the specific dwelling types that need to be provided for. Within the dwelling type of multifamily, it requires that you provide a reasonable range of multifamily development. And this testimony will demonstrate, in part, together with other testimony that's to come from the applicant, that there's not a reasonable range of multifamily development provided for by the township zoning ordinance. And I understand that the township's going to identify some multifamily development that's occurred or is planned to occur in the township. That doesn't mean that the township has provided for a reasonable range of multifamily dwellings in various arrangements. My position is that it hasn't, and I need the opportunity to prove that, and this testimony is part of that.
Can I address this, Mr. Chairman?
Yeah, go ahead.
So I think that we're getting a little bit bogged down in the objections. And if we're talking about how long this testimony is how long it's gonna last, then, you know, I think the board, I mean, the chairman said he wanted to hear some testimony as to fiscal impact. I and the board know what the standard is with respect to whether an ordinance is unlawfully exclusionary. And so to the extent that the testimony about fiscal impact, it can be related to whether a multifamily housing is being unreasonably excluded in the township, then it will be relevant. So I think that the board wants to hear that. It's you know, there's potentially going to be some objectionable questions, but I think that getting bogged down in the objections at this point is not very helpful.
If I may, I do appreciate that position. However, this is a slippery slope. So if you open the door for any testimony on the fiscal impact study, I have 31 pages of details. I'm permitted to cross-examine him on the background of that. This is going to take hours. It's not relevant. I mean, the summary report gets to the highlights and talks about the benefit to the township and the benefit to the school district. And when I say benefit to the township, I'm not talking about, parks and trees and roads. I'm talking about the budget of the township. That's what's in the analysis. Again, there's nothing that links this between whether or not this township ordinance is exclusionary as to multifamily dwellings.
You haven't heard the testimony yet, and the report that I shared with you as a courtesy in advance of the hearing is not the testimony.
Well, you're submitting the reports as exhibits, or at least you did with the first one. I would anticipate you're going to submit the other exhibits. You can't open the door for the testimony, and unless you have to qualify that testimony. The board has not accepted him as an expert. He's a fact witness on fiscal impact study. But again, this board can exclude irrelevant evidence, and our position is you should.
For both council, I have a question. On 604, it says about different housing types, single family, duplex, and higher density. It really does not say what that density should be, nor does it say that the township, and I keep saying township, but I mean all municipalities, will be telling the developer that it has to be a certain type of development. Developer comes into the municipality with a plan, in this case for multi-family. And that plan, which I know is under the ordinances, what is being questioned, but that plan stipulates that it's going to be a multi-family development. Am I reading 604 correctly?
I'm afraid I don't understand the question.
I don't
It
either.
says other types of development, but when you read 604, it says single family. And if it's a single family development, the applicant that comes in front of the governing body says, here's how I want to develop this land. It's basically 3 homes per acre. Here's the roads. Developer comes in and says, I want to put high density in. And it says, I'm going to put 5 homes, 5 units per acre. The township doesn't say any more than fine. If you meet all the other requirements, it's approved. They don't tell them that they have to be affordable housing, and I know that was discussed in the first one, but let's say subsidized affordable housing. There's a development in this township with high density development that when the applicant came into the township years ago to build, he built more on the higher end. Township could not say, no, you can't do that. So, as long as the density of what I'm trying to say is 604 just says, as long as you allow higher density for units per acre, then it meets, in my opinion, it meets the requirements of 604. So now that's whether economically it's a good time to build or not. That's a decision that a developer has to make at a particular time. And I understand that, but
if I may,
please
try and address your question.
clarify what I'm saying. I
Sure.
appreciate it.
Sure. So 604 requires a township to plan for a reasonable range of multifamily dwellings in various arrangements. It does not say that the township has to plan for low-income multifamily dwellings. It doesn't say that the township has to plan for new family dwellings. Certainly, the township could plan for adaptive reuse of multifamily dwellings, warehouses. I mean, that has happened in the township. So the township's position is they've met the standard of 604 because they do have a reasonable range of multifamily dwellings in various arrangements. There's no requirement to be high density. There's no requirement that it be 10 to 12 dwelling units per acre or 25. There is a range, and new, it could be adaptive reuse, and it's in varying districts. So from this township standpoint, we've met the requirements of 604.
Yes. If an area is zoned for multi-family, but it also allows for, you know, single family or duplexes or whatever. And the developer comes in that multi-family zone or high density zone, excuse me, and decides to put in single family homes. And everything needs to, can the township say no?
If it's a permitted use, no, they cannot.
And that is also how.
Correct. It's the developer's choice.
Right.
If
Since you guys have opened this whole thing up 604. One of the MPC, again, doesn't say you need to have so many units per density levels. One thing the MPC doesn't recognize is low density, medium density, and high density definitions, correct? Would you both agree to that? Not necessarily anything since 604, saying the MPC recognizes the term high density as well as with the courts in the state of Pennsylvania.
I'm gonna have to pull up my MPC.
So let me make it easy. One of the things I would suggest, so we can keep this moving, is that both solicitors submit to our solicitor so he can submit to us what your opinion of 604 is and what it defines. That way we can just keep this thing moving.
I think that that's the argument that has to be made on both sides, and Ms. Piper just explained where the township's position, what their position is. But the question is really whether reasonable, providing for a reasonable range of housing in all those types, including multifamily housing, requires a density at the level that of more than what the township zoning ordinance requires. And I think that there's definitely will be arguments on both sides as to that question. And I you know, as to whether the fiscal impact really is relevant to that question, I still don't know. I mean, part of the problem is we didn't see the reports ahead of time. We don't know what the testing is going to be, and we don't know whether is material to what the board has to decide.
And I would submit that the township certainly will have a position on this case, and the township will have an opportunity to present its case. This is the time for the applicant to present its testimony and evidence, and that testimony and evidence will come in pieces with different witnesses. And then it's the applicant's burden to establish that evidence supports the applicant's position as to the invalidity of the township's ordinance. But I want to be clear that the township's position, the applicant's position is that the township zoning ordinance is invalid, not only because the density provided by the ordinance of 5 dwelling units per acre as the maximum density in the township's highest density district that allows multifamily housing, but also because, and from testimony you'll hear from Mr. Samuels tonight, because of the market forces and the realistic implications of the 5 dwelling unit per acre restriction and being the same density or similar density permitted for single family housing. And also the zoning ordinance's area bulk restrictions on multifamily housing, which Dr. Cassidy testified to. The township is not permitting any meaningful market rate multifamily development in the township. The township will have the opportunity to attempt to establish otherwise, but that's the part of the case that I'm presenting, and I would ask for the opportunity to present the evidence that goes to it. And the board will have the opportunity to evaluate the relevance and the applicability of it, and the township will have the opportunity to present its own testimony and evidence.
If I may, we certainly have no objection to moving on and getting into the testimony about market implications, because I've seen that report and I think there's information in there that will be useful to you. Our objection stands as to the fiscal impact study. It has no bearing on this case. And Mr. Hanson, I do want to address your question about the MPC. There are no specific definitions about low, medium, or high density in the MPC. So we're limited to 604, unfortunately.
I'll clarify that the court has made some in their judgment says referred to the term high density. Low, medium, high density.
Sure.
May I proceed?
Let's proceed with the testimony and try to keep it on the track where it is relevant to what we will eventually have to talk or decide on.
Mr. Samuels, I'm going to show you a document marked A44 for identification. And I'm jumping ahead a little here because I don't want to get bogged down on the fiscal impact right now. Can you identify that?
Yes, this is a report that I produced, trying to relate the market implications as it relates to density limitations in the RM district.
Did you look at the level of multifamily housing currently under construction in Lancaster County generally?
I did, yes. On page 2 of our report, there's a table that indicates the new apartment construction activity that's going on currently in Lancaster County. See the range from 52 to 204 units. There are 2 of them are in suburban locations, 4 of them are in Lancaster City. Lancaster City properties are being developed to a very high density, ranging from 20 units to the acre, or 15 units to the acre, all the way up to 733 units to the acre, because it's 142 units on 0.19 of an acre. The 2 properties that are being constructed in the suburban areas, one in Penn Township, one in Manheim Township. The Penn Township property is 190 units on 21 acres, just over 9 units per acre. And the Foundry in Manheim Township being developed 97 units on 4.5 acres, or just over 20, almost 21 units per acre.
Would you agree that the Penn Township and Manheim Township are comparable to East Hempfield Township?
Yes.
Did you analyze the level of multifamily construction in Lancaster County over the last 10 years?
Yes, and also I presented renderings and photographs of each of those properties so that we can understand what that construction looks like.
Mr. Samuels. At the apartment, I know I determined the mid-rise, to me that's 5 to 7 stories, would you concur?
It's a reasonable definition. I think it varies by location. It's like the definition of low, medium, or high density.
Okay, but for your, give us some context here.
Okay.
Your 733 units, density there, you have listed as a mid-rise. That's
Well,
7 stories, 8 stories, is that 10 stories?
So 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. As I said, there are renderings or photographs of each of them, so you can get an idea.
Just to give us some context so we know what we're
Yes.
talking about. Thank you.
Yes, sir. So I'm trying to put the multifamily development that's occurring in Hempfield Township in context. Again, we looked further at the multifamily development that has occurred in Lancaster County from 2015 to 2022. And we have 2 charts that look very similar. One has an address for, it's on page 6, an address for each of the complexes. One has the municipality. That's the only difference in the 2 charts. So you can understand what municipalities are providing the. But as this table summarizing at the bottom, there are 11 projects that were constructed during the plan period, 1,416 units, averaging 100.9. The minimum density was 6 units per acre. Average density was 15.91, and the maximum density was 55.9 again in Lancaster City.
And how does that compare to the level of multifamily construction in the township?
It's dramatically different than the multifamily development that has occurred. And all again, I have renderings of our photographs of each of those complexes. On page 10, we have a chart that shows what the multifamily development in East Hempfield Township has been. Now we've excluded Tobacco Road apartments only because it was an industrial, it was a warehouse conversion to apartments. And so the densities were greater than what were otherwise allowed in the municipality. Also, Lansville apartments, same thing, 27 units per acre, but it was half of 24 of those units were in a tobacco warehouse, 24 units were in new construction. And that high density was achieved. But we looked at what the development trends were over time and tried to put it into a context of the change in the zoning code. So before the zoning change, there were a number of projects constructed, averaging 237 units in size and averaging 9.17 units per acre. After the zoning change, there was only, from between 95 and 2014, there was only 1 complex, and that was Landisville Apartments, which was half of it was conversion. The tobacco in the house, half of it was new construction, and it's located along railroad tracks. And then from 2015 to 2024, there were only 2 substantial apartment projects. Willows in Landisville and Courts in Emmett Spring, and those densities are 6 to the acre and 9 to the acre. And the only way that they were able to achieve those densities was because the remaining parcel, they're mixed use projects, planned developments. They were, I would say, they're more of an afterthought than a plan to be apartment developers. When you have a large tract like the old Lion Stream, that's 113 acres. You develop the property or on the property as you want to develop it as best you can in appropriate size and configuration. And then if you have some additional land left over, you figure out what you're gonna do with it. And in this case, there was a little bit of land available for the construction of, 44, apartments. And they were only able to achieve that density because it was part of a larger development.
With respect to the 3 projects that you identify on the table on page 10 of A44,
Yes,
those are 44, 60, and 48 units respectively, correct?
correct.
And the projects below that are all 100 or more. What's the difference?
The difference is the zoning, when those were constructed, those early ones were constructed, permitted higher densities. But the reality is that up to this point, there hasn't been any true development of multifamily housing that's consistent with what's happening in the marketplace. It's not only happening in the Lancaster County marketplace, it's happening all over the country. I find it interesting that we're discussing 5 units to the acre, 10 units to the acre, whatever. But I'll tell you, in the Philadelphia suburbs, on infill sites, the densities are 40 and 50 units to an acre. It's something that hadn't been permitted, hadn't been accepted for a long, long time, but the marketplace has shown that there's a certain physical nature of apartment living and features of apartment living that has changed. And the world has changed, but the zoning code in East Hempfield hasn't changed with the world.
Did you look at the level of multifamily development in Lancaster County generally going back into the 60s?
We did on an earlier chart back on page 6, I believe it was.
Based on the charts that you've reviewed and the testimony about the densities in Lancaster County, generally the densities in the other townships versus that's occurred in East Hempfield Township, do you have a conclusion and opinion as to the comparison between the two?
Yes, the densities in other municipalities in Lancaster County is much higher than the 5 units per acre that's permitted in the RM district. That is the highest density that's permitted in the code.
Are you, and you testified earlier that you are familiar with the East Hempfield Township zoning ordinance of 2014?
Yes,
And you're familiar with the maximum density restrictions in that ordinance?
yes,
And I think you've already testified, you're aware that the maximum density in the highest density district, the RM zoning district, is 5 dwelling units per acre for multifamily.
5 for multifamily, 5 for townhouse, 4 for.
Did you review Dr. Cassidy's testimony that developing multifamily housing with a maximum density of 5 dwelling units per acre would be economically challenging?
I did hear that. And yes, it is much more difficult than.
Objection, he's not qualified to render that opinion. That opinion was given by Dr. Cassidy. He's been qualified as an expert appraiser and market analysis, but as to construction and, you already have they've already offered testimony from Dr. Cassidy. This witness is not qualified.
I'll move on.
Okay, thank you.
Did you consider the implications of the 5 dwelling unit per acre maximum density restriction on the development of multifamily housing in East Hempfield Township?
Yes, I did.
What effect does the restriction on the maximum density have on multifamily dwelling development in East Hempfield Township, in your opinion?
In my opinion, it basically eliminates multifamily housing, new development, in East Hempfield Township. The solicitor, the township solicitor was very nice to recognize a basic economic concept. We always have to deal as appraisers, valuers, and as developers, because I wasn't always an appraiser, I was a developer as well. And I believe it's a mischaracterization of what appraisers do in saying that we don't understand construction, we don't understand the economic development. This is what we do every day of the week, every week of the year, and have for many years. But anyways, there's a very basic concept that needs to be discussed, and this is, I think, very significant in this instance. Because the solicitor said, oh yes, the question was asked, and the solicitor answered, yes, there are situations in the township where developers are choosing to build single-family detached residences as opposed to building apartments. And it is a choice, but what it is, it's a manifestation of the economics of the marketplace and the competitiveness of the marketplace. We have basic set of procedures that we use as appraisers. And that is called highest and best use. The highest and best use is an interesting concept, but it's a concept that people don't understand, because not only illustrative and instructive as to the development, how townships, how municipalities develop, but it'll be eye-opening from my point of view to you to understand that concept. Because when a developer looks at a site, remember, I was responsible for land acquisition, I was responsible for approvals, I was responsible for development activities for a developer. We had to look at a lot of sites. The first thing you do is legal permissibility, right? We have to determine what is legally possible, unless you want to undergo a zoning change. But as a developer,
I'm going to object to this testimony. Again, the witness is going pretty far afield from what the question is. I think everyone at this point has probably forgotten the question because he just continues to ramble.
I agree.
Thank you.
And before we go on, Samuels, on the applicant's exhibit A44, page 12, you have written the ordinance generally inconsistent with the residential density development goals of growing together, which is the county comprehensive plan, and the ordinance of the general zoning law. Are you saying in that sentence that generally inconsistent is the same as generally consistent?
What I'm referring to is that when the ordinance was first put up for adoption in 2014, the county wrote a letter of review. The county is under Act 247, reviews land development, zoning changes, planning changes. They said that under their existing comprehensive plan for the county, that the average densities that should be achieved are at least 7.5 units per acre. That they believed that the 5 units per acre maximum was not consistent with their beliefs as to how the county should develop.
Understand, and I know what that county plan says, but 303C of the Act 247 says that a municipal comprehensive plan is to be generally consistent with the county plan. And they leave that basically up to the municipal government. And that the zoning ordinance shall be generally consistent with the municipal plan. Nowhere does it talk, and I don't know if this is your writing or the letter from the county, about generally inconsistent with. So, again, that's part of what our final decision is going to be on this case is the ordinance, the zoning ordinance, generally consistent with township comp plan and the general, which is generally consistent with the county comp plan.
I can't comment on the consistency or inconsistency, because I believe that's a judgment call.
I would agree with you there, and that's a judgment call of the governing body, but
Yes,
the using a term of and again, I don't know if this is your language or the county's language. Inconsistent, generally inconsistent. I mean, that does not nowhere show up in the MPC, especially in section 303C.
can you point out where inconsistent is in my?
Mr. Hur, if I may, I believe you're reading from a section that he has quoted from the county letter on page 12, if I'm looking at this. I believe that's a block quote from the county, not his opinion.
I know, but I wanted him to say that it was the county saying it's inconsistent and not what he's using as.
Mr. Hur, I was going to get to that.
Well, I'll take it one step farther. Is it consistent or is it inconsistent? Because the county apparently used the same, both words in the paragraph.
Yeah, the county says the ordinance is generally inconsistent with the residential density development goals of growing together.
Right, but above that, you have the draft zoning ordinance is generally consistent with the growth management goals of growing together. So which is it? Consistent or is it inconsistent?
Generally consistent.
I think it's generally consistent with other issues other than with regard to densities. I think the modifier is densities. It's inconsistent with the residential density development goals, but it is consistent in other ways.
But I would argue with the county planners, at the time that the Board of Supervisors of East Hempfield Township developed this, they were saying that, in their opinion, that the zoning ordinance met the requirements of 303C, that it was, in their opinion, generally consistent, and that's where they put it into words, put it on paper, and move forward with it. All I'm trying to get at is that is the term generally inconsistent the same as generally consistent? I would contend it isn't, and that's not what was written back in the late 80s when they recodified the Act 247. So, and you're just referencing with the county, but I wanted to make sure that that's was on the record and that wasn't your language.
It's not my language.
Okay, that's what I needed to know. Now, with that being said, we are taking a small break. I don't know if anybody else needs it, but I know Cheryl needs to rest her hands. So let's take 5-10 minute break and pick up where we left off.